them secret. Judge Reinhart gave us some clues to that today by telling us, for example, that at this juncture he is not inclined to keep the entirety of the search warrant application and its affidavit under seal, meaning that he understands that the public is going to likely be entitled to some parts of this warrant application and its affidavit. He will consider redactions proposed by the Department of Justice, which are due to him August 25th. He will accept any briefing of the Department of Justice on those redactions. He will review those materials, and he will enter an order specifying what information, if any, will remain sealed and inaccessible to the public.
What is your response to the government's argument saying that following these redactions that are made, there may be nothing substantial left behind?
Well, I think Mr. Tobin made the right response there. It is up to the public to determine what is meaningful in this investigation. Certainly, Florida has had its share of high-profile investigations. We've lived through Casey Anthony. We've lived through George Zimmerman. We know what redacted court files look like, and we know how to make meaning of them. So if the court is inclined to issue a document with just the first line redacted or unredacted, then that's what we get. And it's up to the public and through its surrogate, all of you, to figure out what the meaning is behind that. But it is not the government's job to tell the public what is meaningful in terms of the release of its own information.
What is your response to the argument that some of the witnesses' accounts are so specific that they would be basically outed or identified by virtue of the affidavit?
I think Judge Reinhart is going to protect the identity of confidential informants, and that's probably the right outcome here. We don't want, none of the media interveners want to jeopardize the safety or security of a confidential informant. It is very common in these situations that information that would lead to the disclosure of their identity is kept secret. However, it is important to note that simply saying somebody works for a particular agency is not sufficient. Perhaps saying their title, their post, the number of years they've been in position, and other identifiers may get us there, but the generic fact that there are confidential informants working with the government is not something that I would think is subject to protection.
Can you explain what was unsealed today, and if we're going to get anything new from that?
Today, you're probably not going to get anything new from it. But today what was unsealed is the motion to seal the search warrant, which you all have the underlying search warrant, and the order on the motion to seal the search warrant. I would expect the motion to be fairly generic and describing that we have a search warrant, Your Honor, that we would like you to seal, and I would expect the order to be fairly generic. We agree that your search warrant should be sealed.
Did anyone mention the waning credibility of the FBI?
Nobody mentioned the waning credibility of the FBI specifically. However, Mr. Tobin did make the argument that this is a proceeding that's about the credibility of all the players. So whether the judge is doing his job, whether the DOJ is doing its job, that is the proper function of these access proceedings and why the public is entitled to access. That is the public interest. We are entitled to monitor the affairs of our government at all levels. And that is the interest in this essence that we were asserting today.
Did the DOJ offer any clues as to what could be in that affidavit today?
They didn't offer clues as to what's in that affidavit in particular, but they did tell us that it includes a roadmap for the investigation as it stands right now. It explains the scope and breadth of that application, or that investigation, excuse me, and it has a number of confidential informants and witnesses whose ongoing participation may be jeopardized by the disclosure. So generically, the government described the categories of information in the search warrant, and that's why it's very important for Judge Reinhart to look specifically at the search warrant affidavit in light of those, in light of those statements that those types of categories are included in the materials.
To clarify, once they've come back with what we want, what we say can be redacted, is that automatically released, or does the judge still have to say, look, I'm going to decide whether or not this is released? I'm just reading an article that characterizes it one way and not the other, so I just want to make sure I understand that.
Yeah, that's actually a very good question for those of you who are not inside the court hearing. Judge Reinhart actually put forth a procedure that he's going to use in this case. So August 25th, the government will propose its redactions to the search warrant application and its affidavit. They can also file a brief at that time explaining why they are requesting the redactions. At that point, Judge Reinhart will review the requested redactions and review the documents, and he'll make a decision. If he agrees with the government, he'll enter an order agreeing with the government, and we will get whatever it is that the government and he have determined should be released. If he disagrees with the government's requested redactions, Judge Reinhardt is the ultimate decision maker here, so he will enter an order disagreeing with the government's redactions, but give the government time to appeal that order before he releases the search warrant and its affidavit. Because, of course, if he didn't do that and it became public, the government would essentially lose its right to appeal. So if he disagrees with the government's redactions, he will give the government a chance to appeal that order before he releases the warrant application and its affidavits for the public.
So as far as timeline, when do you think we would actually see whatever is going to be released?
It's really hard to determine. In these access cases, they tend to take a fast track. I was actually pleased to see the Department of Justice say they only needed a week to submit their redactions. That was very kind of them. Oftentimes we see a much longer period. I think Judge Reinhardt understands the public interest in these materials, so I think he'll make a swift decision. I'm not going to hold him to a certain time frame because I just don't know. And then if there is an appeal, I think you'll have, members of the public and press pushing for an expedited appellate review system so that the public can have access to whatever it is that the court is going to rule we can have access to rather quickly. In some, it won't be months, but it won't be a week or two either. Anybody else?
Thank you.
Thank you so much.
Thank you.
Yeah, thanks, guys.
Name one more time, sorry.
Deanna Schulman, D-E-A-N-N-A. Schulman, S-H-U-L-L-M-A-N. Schulman Fugate, West Palm.
Do you speak Spanish by any chance?
Not well enough to be on air. I read it and write it. I can't speak it well enough, sorry.
Thank you.
Yep, thanks guys.
Thank you.
Thank you very much.
Is that everyone?
Yeah, that's
They said that Ms. Bob was in the first row. Was that not accurate?
Oh, I don't know, actually. I wouldn't recognize Christina if I saw her, so I don't actually
They said that she was at the court, but just to listen, not to testify.
So to clarify for the record, no attorney argued on behalf of Mr. Trump at today's hearing.
If the Department of Justice goes forward with criminal charges, will that change the timeline for the affidavit to be released? Because that's a different matter. Like if the person charges, then maybe it's easier to get the affidavit out because charges might be filed.
Yeah, that's right. It's not unusual once all charges have been filed for the government to be willing to release more materials and the courts to be willing to do that as well. But please keep in mind in this investigation, we don't exactly know who the potential indictees or arrestees are. I mean, we shouldn't assume that it's President Trump. It may be others. It may include him, but it may also be others. And so even if we see an arrest come down, it doesn't necessarily mean that the investigation is concluded at that time.
And so that wouldn't change maybe the decision by
time will tell, yeah. We don't know the breadth of the investigation. That's the problem. So,
how meaningful it is by the fact that DOJ had Mr. Brad being the one that presented the case and not Mr. Gonzalez, which is the DA for the Florida district.
I mean, I love Tony. I've worked with him for a number of years on these types of matters. I think the DOJ is taking this very seriously and wanting to send in some of its senior officials so that, the public is aware that the DOJ finds this investigation to be important at the highest levels.
So you mentioned Thursday. At what time did they say?
Noon. Thursday at noon, the government must submit its redactions, its proposed redactions, and any briefing it'd like to offer to the court. Thursday the 25th.
Thank
you guys aren't going to actually be here next Thursday, right?
No, that's just the filing. So for those of you who follow the court beat, you'll just see sealed docket entries come up next. I would assume they'll file them on the 25th. I don't see why they have an incentive to file early, but you'll see one or two docket entries. It'll just say sealed filing, but you'll know that's what it is.
And they will have meetings privately. That before that, the judge might have a consultation to try to figure out those line by line.
They seem to have decided at this juncture to do it through a written briefing process that will be filed on the docket as a sealed docket. I think Judge Reinhardt does have that opportunity open to him if, for example, there's wide disagreement between his scope of permissible redactions and what the government is suggesting. So that could happen, but it would happen down the road, and we would likely know that it is happening, even if we were not permitted to be present.
Thank you so much.
Yep.
I'm sorry, we got a back shot. Can you tell us again what happened just that?
Just a brief soundbite. Yeah, so today we had a hearing on whether the public can access the probable cause warrant application, the warrant application and the probable cause affidavit. The judge heard argument from the government and from the media interveners and other interveners on whether it should remain entirely under seal or should be released in some redacted form. The government advocated that it be left entirely under seal. The media interveners advocated that Judge Reinhart look line by line and item by item to determine whether particular information is justifiably still under seal. The judge seems to agree with the media interveners to that extent in saying that he's not inclined to seal the entirety of the search warrant application at this time, but he is giving the government an opportunity by next Thursday at noon to provide proposed redactions as well as a brief on why the government believes those redactions are appropriate. Judge Reinhart will review that briefing and those redactions, and he'll enter an order from there.
Perfect. Your name?
Deanna Schulman, Deanna Shullman, Schulman Fugate, West Palm.
Thank you very much.
Yep.
Ms. Schulman, one quick question.
Yeah.
Did anybody raise the public interest in knowing or assessing the credibility of the government sources?
Yeah, that's absolutely at the core of this. So the core of public access, and remember, this is not a right of media access, it is a right of public access, and the core of that right is the ability to monitor the functioning of the government. Whether it is the government, the DOJ itself doing its job and its investigators, officers who executed the search warrant, the officers involved in gathering the materials that justified the search warrant, and of course the court, who's asked to look at whether the search warrant should remain under seal. Or, sorry, the search warrant application. The search warrant's already public.
Did the judge agree with this premise?
I don't think that there's any dispute that this is a case of extreme public interest. I don't think that the DOJ tried to argue otherwise, and of course I think Judge Reinhart recognizes that. You know, he's a very experienced judge, so I think he very quickly recognizes the significance of this investigation in particular. Yep.
Just to make sure we understand about what was released today. It was just
The motion to seal the search warrant.
motion to seal it.
But you remember you have the search warrant.
Yeah, we already have it.
Yeah, so now that's why you're getting it, right?
Yeah.
So the motion to seal that search warrant is what justified putting it under seal in the first place. And so that motion's coming out, and so is the order on that motion. There's no point in keeping them under seal anymore because you have the warrant.
Right. The motion to seal, was that filed like?
Those are dockets 1, 2, and 3 on the. If you look on Pacer, they're going to be under seal on Pacer as 1, 2, 3.
Okay.
If you go to 57, that's what should come out. So that 57 is currently designated as a sealed docket when we went into court, but the court instructed the clerk to unseal docket 57.
Okay, so that was the motion to say, hey, don't put out the search warrant, even though it ended up being released.
Yeah, because it was filed before.
Yeah,
Yeah.
gotcha.
So it's just a little housekeeping. If you have the warrant, you might as well have the motion that sealed it.
Right, got it. Okay, great. Thank you so much.
Yep.
Appreciate it.
What is that criminal coverage sheet exactly? Because it's 3 documents, so the motions to seal, the seal motion, and then what is that?
A criminal cover sheet is really actually, a very benign document. It basically has a checklist of what type of proceeding this is, who the parties are, what the relief is that's requested. It's usually a 1-page document that you check particular boxes for what's important. What kind of proceeding you're opening. Because to get that search warrant, they had to open a proceeding to ask the court to execute and sign off on the search warrant. So that's just the cover sheet. Nothing major.
Do you feel is that the judge really wants to get something out? He mentioned the fact that it was a public interest, and I mean, the media has argued that it's a historic event.
Yeah. The judge already said he's not inclined to seal the entirety of the search warrant application and its affidavit. So I think we will get something out of this proceeding. It remains to be seen how much. Whether we get a big black page or we get something of substance.
Is the DOJ willing then to work with that? Because they were a little concerned about how much they were able to unseal.
Yeah, the DOJ's position in its papers and in court today was that the entirety of the search warrant application and its affidavit should remain under seal. So, they will have a week now to sort of negotiate that. And perhaps, given Judge Reinhart's comments on the record today, they will temper their request for redactions. But they may continue to assert that the entirety of it should remain under seal.
Thank you so much.
Yep.
Appreciate it.
Being in like a historic event, the FBI going to the former president, what does that mean for the future? What do you think? Does this create like a ripple effect per se?
No, I don't necessarily think so. I mean, I think it's easy to get lost in the high-profile nature of this particular search warrant. But keep in mind, the Southern District of Florida will enter and execute dozens of these and hundreds by the end of any given year, or maybe even more. So this This particular search warrant application is not getting any different or special treatment than any other would under the law. It is not routine for the public because it's very, scandalous in the sense that it involves a former president, but it's very routine for the criminal justice system to apply for, receive, and execute on search warrants.
What do you think the biggest impact potentially of the process of how they got more coming out?
I think it's about government accountability. It's about, allowing the public to assess for itself whether the government overstepped, overstated, stayed within the lines. At the end of the day, this exercise is so that all of us have a right to understand whether the government has overstepped or stayed within the bounds of the law in seeking this search warrant. And that's good for everybody.
All right, understood.
Okay.
That's all I got.
Yep.
So you have a good day.
Thanks. All right. Bye, guys.